Hello everyone, thank you for joining us today. Welcome to our session where we're going to be discussing unbundling services. Joining me today are a panel of experts in this area. My name's Simon Holtsby, I'm Head of Communications at the SRA. I'm not an expert on legal matters, but thankfully our panel are, and they're going to have some great insight from a pilot we've done in this area. And then we're going to throw it up into you to ask questions around this subject. And I'm sure those guys will have some great answers to give you. Before we go on, as I say, I'm not an expert, and I'm sure all of you are well aware of what unbundling of legal services is. But just in case anyone else isn't, unbundling is when you take a legal service and you divide it up into specific tasks and elements, which potentially gives the opportunity for consumers and the legal services providers to split some of those tasks up as to who does them. And this can create opportunities in terms of affordability, in terms of access, and potentially benefits for the law firm as well. And hopefully we're going to get into some of that shortly. The reason we're talking about this today is we've recently completed a pilot in this area where we worked with a number of firms. We wanted to really look at how unbundling of services can increase access without necessarily being detrimental to customers. We wanted to look at what barriers were out there for legal services providers, which may be inhibiting them from working in this area. And we want to see what could be done with both firms and consumers to hopefully encourage greater uptake of unbundling. The session will begin with a brief overview of what we found. And as I said, then we'll be opening it up to a question and answer. We really want to hear what you want to ask us. We've had some great pre-submitted questions, but we've got plenty of time today for any you come up with. If you look below the video, you can see this broadcast. You will see a short link where there is a link. If you click on that link, you can put your question and it will come live through to us here to put through to our panel. So please, please submit a question. You can let us know your name if you wish, or you can do it anonymously. But I would say get in there early. The worst thing would be if we get right to the end and don't get time to get your killer question in. So let me introduce our panel. First of all, Jackie Griffiths is Head of Regulatory Policy at the SRA. We also have with us Lola Bella, who's the Legal Services Consumer Panel Manager. And we have Paul Smith. Paul is Senior Risk Management Consultant for Travellers Europe, who work with law firms providing PII cover. So obviously, that's one of the big issues that we know firms want to talk about in this area. So, without any further ado, I'd like to hand over to Jackie, and Jackie can give a brief overview of what we found on the pilot and what we're doing in this area. Jackie.
Thanks, Simon. Sorry, I was on mute there. Classic Teams mistake. You've seen some slides appear in front of you just with some key findings from the pilot, which I'll just take you through in 5 minutes, and then some next steps that the SRA are planning to take as a result of that pilot. So first of all, looking at from the public and consumer point of view, we found that awareness of the concept of unbundling and the availability and the possibility of being able to unbundle is really low. So of the legal services providers that responded to our survey, 40% of them had not heard of unbundling as a concept, and consumers, that was even much higher. So 80% of consumers who hadn't unbundled that responded to our survey said they'd not heard about it. So if a consumer has not heard that unbundling might be a possibility, they can't ask that legal services provider if it might be applicable in their case. And if the provider hasn't heard about it, then they're not considering whether it might work for their firm, whether it's something they could offer, and they're certainly not advertising that for the consumer to know about. So we think that's quite a significant finding from the pilot. Also of real significance to us is that we think unbundling has the potential to increase access to justice. And that's particularly relevant to us at the moment as we're thinking about the cost of living crisis and how many consumers will be able to access legal services going forwards. So 25% of those people that unbundled said that it would help them to afford otherwise unaffordable services. And in fact, 21% of the respondents who had unbundled said that they wouldn't have been able to have the legal service at all if unbundling hadn't been available to them. So that's really a significant finding again for us. Also, Unbundling, those earning above £60,000 a year are least likely to unbundle, but it doesn't necessarily mean that it's the very lowest earners that unbundle. In fact, it's 55% of consumers who unbundled had an income of below £40,000, but that means 45% had an income of above £40,000. And there are many reasons for that we still need to explore in detail. Clearly, you need a certain amount of confidence and a certain amount of legal capability if you're going to take on some of those tasks yourselves, and you might expect that those who are higher earners maybe have that more confidence and that more sort of assurance that they are capable of taking on that work. So that's something that we need to look at a little bit more. We also found that unbundling is particularly attractive to those of us who like to feel a bit more control over our case. And so that is another attraction despite the cost. So it's not always a cost driver to unbundling. There are other reasons that consumers are attracted to the idea. We also found that there's no significant difference in consumer satisfaction levels with the legal service, whether they unbundled or not. And I think that's a finding that the Legal Services Consumer Panel have found before. And in our particular survey, there was 1 percentage point in it. So 80% of those who unbundled were satisfied or very satisfied with their legal service, compared to 79% of those who had a traditional service. So my researchers would tell me that that's so insignificant that it's not actually a real difference. So if we look at the significant findings for firms, which will appear on the screen any minute, so 26% of firms are offering unbundling for one or more of their services that responded to our survey. And actually, the firms offering unbundling tell us that there are benefits to them. It does help them to attract more clients by offering that unbundling. And that makes sense if you think about the percentage of consumers telling us that traditional services are unaffordable to them, and unbundling is the only way that they can access legal services. So, especially as the cost of living starts to bite on people, you know, legal services could start to look an unaffordable luxury to people, and so offering unbundling might be a way to attract more clients for firms. But it's fair to say that concerns have been raised by firms through our survey and more generally, and concerns seem to centre around impacts on indemnity insurance premiums, and Paul's here to talk to us more about that today. And negligence action if things go wrong is also quite prevalent, and so we'll talk about that in a minute under barriers. And there are also concerns about how do you determine whether your particular client has the capability that you need, and for which tasks. How do you divide up that work? How do you decide what's reasonable to expect of the consumer? And some firms, particularly those taking part in the pilot who already offer unbundling, told us that if they've got technology and systems in place to help them to divide that work, to help them understand a client's capability, then that has really helped them in that regard. So it's not insurmountable. If we can move on to talking about the barriers that we found to unbundling. So these are mainly focused on firms, but also some on consumers. So what is it that's stopping unbundling from really taking off in the legal services market? Because it's a really small percentage of transactions that are unbundled still. So as I've already talked about, indemnity insurance implications is a big barrier for firms. Firms taking part in the survey told us that they were concerned that their premiums would rise as a result of offering unbundled services. And some insurers that we spoke to confirmed that they do see unbundling as a higher risk when it comes to legal services. And so there may be an impact to insurance premiums. And so what we need to do is think about how that can be mitigated. Is it inevitable in all cases? And so we've got Paul along today as one of our experts to talk about it. Firms also talk about the concern about negligence action if something goes wrong, and where firms are concerned is that if the consumer is responsible for doing something and they don't do that right, or they don't do it on time, will the firm be held accountable? And there have historically been a couple of headlines, quite scary headlines, on where firms feel that they've been held responsible for something that wasn't within the scope of the retainer agreed. And so we have looked at the cases involved, and we've had our legal team have a look at them, and we found that they do turn on their specific facts, as you would expect, and actually there are things that firms can do to make sure that accountability and responsibility is really clear, and to really mitigate that risk of ending up in a negligence action if things go wrong. And so we're going to look at how we can get more information out to firms about that. And then awareness, which I've already talked about, is a real issue we think that we need to try and do some work on to overcome, because we think awareness is low on both sides of the fence. And then technology is a barrier. So lots of firms say that they would like technology to help them when it comes to dividing those tasks, to keeping track of those tasks, to thinking about consumers' capability. But they just don't know where to start in procuring that technology, or they have limited resources and not sure that they can spend money on the right technology. And so that's a real barrier for some firms. So what are the next steps that the SRA are proposing to take here? It's at a really early stage at the moment, but the Legal Services Board, they are currently conducting a review of the financial protection arrangements for consumers, and we are feeding into and collaborating on that review. And as part of that, we continue with our conversations with insurers as well, to understand whether there are things that firms can do to mitigate the additional risks of unbundling, and try and mitigate any rise in insurance premiums that unbundling might bring with them. We're also looking at what guidance can we develop for firms. So I talked about the concern about negligence action. Is there guidance we can develop for firms to give them some tips on how to avoid finding themselves in that position? And is there information for consumers that can raise awareness of consumers about unbundling and raise confidence as to their ability to engage in an unbundled service? We're planning some roundtables with the Law Society, with the Legal Services Consumer Panel, advice agencies and charities, and they really are for two reasons. So firstly, the title unbundling is not particularly well received or understood in the outside world, and I have to say it took me a while to get my head around what we meant by unbundling. And often people see it as an inferior service. They associate the term unbundling as somehow inferior. And so what we want to do is have a conversation. Is that the right term, unbundling? Is there a better term that we might adopt? So that's firstly what we'd like to do. And then secondly, we'd like to work with advice agencies and charities on raising their own awareness and understanding of unbundling, so that when they are working with consumers and signposting them towards solicitors, they can make sure that those consumers know about unbundling and are ready to have a conversation with the legal services provider about that possibility for them. And lastly, as I said, firms don't tend to advertise the availability of unbundling, even if they offer it. At the moment, they prefer to deal with clients on a case-by-case basis, and only tend to suggest unbundling if the client asks for a more affordable option, or they recognise that the client needs a more affordable option. And so what we want to do is some work with firms to explore the practicalities of firms advertising the availability of unbundling more widely, so that consumers know to have those conversations with firms. So thank you. That's it from me. So I hand you back over to Simon to ask us some questions.
Thank you very much, Jackie. And it's worth pointing out that that's very much the headline highlights of our report, a bit of a sneak preview for everyone watching this webinar. The full report will probably be published in a few weeks' time. So if you're interested, certainly keep a lookout for that. There should be a lot more detail and a lot more interesting content to get stuck into there. So as I say, we have an expert panel here. So if you have any questions on what you just heard on the wider subject of unbundling, please get them in. We'd love to go through them. We've had a few already, but plenty of time to get some more in. So I'd like to turn to Lola first, obviously from the consumer perspective, to get your thoughts. What are your thoughts on unbundling, on what you heard we found there from Jackie?
Apologies. the Legal Services Consumer Panel has always been supportive of unbundling. We've been looking at this area since around 2015, and because we were at that time concerned about unmet legal needs, widening access, and we see it as just one part of the solution, not the full solution, but one part. Partly because of some of the things that Jackie said, it's not for everybody, but providers can work with consumers to help to identify which types of consumers this would be good for. So in general, very, very supportive. We've also been tracking the use of unbundling. So how has it been going over the years? We know that in 2015, about 19% of people reported to have used unbundling service. And then that dropped to about 2016 in 2020, and now it's gone back up again, just ever so slightly, to about 18%, but it's not gone back to what it was in 2015, and we would like to see it actually much more higher than that. So we believe that there is scope for more people using unbundling. We think that the areas that definitely need to be tackled is awareness. Consumers need to be aware of it to be able to use it. And we also really think that attention needs to be paid to some of the barriers that providers said that that providers have noted in this space. So questions around PII, questions around how complaint will be handled when they're dealing with unbundled services. And we think that if those are concentrated on and the regulators provide guidance and work with other bodies like LEO to identify how complaints will be dealt with, that would hopefully encourage more unbundling service to be offered to consumers.
And Lola, perhaps we touch on some of those barriers and bring Paul in shortly, but what is it you feel are the opportunities that unbundling brings, and what sort of consumers do you think it will be good for?
So I think Jackie mentioned consumers that have the capacity and the capability, and I think that it will come down to an assessment by the provider. So some sort of guidance around that would be good for providers to have. There's also the great advantage, I think, that we see of unbundled services is in the cost reduction. I think we had some evidence that around up to 40% in cost can be reduced when you use an unbundling. Of course, that wouldn't be applicable to all sorts of services, but there can be significant savings for consumers, and that's a great advantage. Another advantage is consumers, when we did some work around this area, reported just that feeling of being involved in their own matter. They felt empowered by that. So it goes beyond just the cost as well.
And Paul, if I could turn to you for your initial thoughts on the finding of the pilots, and particularly some of those barriers that firms see as potential obstacles to unbundling.
Yes, well, from my perspective, it's I would say as an insurer working with underwriters who underwrite these risks, we don't see a huge amount of work being done at the moment unbundled, but we expect that to increase over time. There's a clear obvious drivers as to why people are attracted to it. We've got it's a response to economic pressures. I think we've seen income stagnating or falling for a number of years. You've got access to justice issues when say legal aid is being reduced, curtailed, and I think also it mirrors what we've seen in legal services generally. As Richard Susskind might say, the decomposition of legal work, so the breaking up of a legal service into discrete tasks, which are then carried out by what are deemed to be the appropriate level of skill and expertise within a firm. So really, we see it as an extension of that. And obviously, there's a shift in terms of demarcation. Who's going to be doing the work? So there's a bit of a blurring going on there. Although I'm interested to hear in terms of what the report has found, that the extent to which people feel more engaged. I think that's a positive, and the service isn't being done to you. You're getting involved, so hopefully satisfaction levels will go up as a result. But I think there are clearly issues for firms and by extension for their insurers. If you're engaging in a new form of service delivery, especially one where you're effectively having an outsourced arrangement with your client, then that's going to throw up issues around communication, coordination, clarity, assumptions, who's going to do what and when. So I think those are issues which are going to inform conversations with insurers. Certainly when I've spoken to my underwriter colleagues, as I say, we don't see a huge amount of unbundled work in the profiles of the firms we insure, but for them, the key issues are going to be, as they would be for a risk management consultant, around the retainer. How is it being structured? In particular, how is it being set up? Is it clear as to who is going to do what? And then you get some of the issues which you come up with any task organization within a legal service delivery. You know, client, what are their expectations? Is the factual matrix clear? What's happening about the structure of the retainer? How clear is that? Assumptions can be lethal in service delivery, whether it's a client involved doing the work or having the service provided for them, and tracking and communication. And I think what I think be interested in seeing as these things develop is the extent to which some sort of structure, say some sort of project management approach towards service delivery, is extended out from firms to actually involving the client. So those are the sort of the issues I think which strike me, as well as, you know, the potential for legal and regulatory issues still to have an impact even when the amount of work you're exposing yourself, your insurer to, is reduced. I can see the courts, and as Jackie's touched on, in terms of the legal consequences, they may not be a consequent reduction, and there may also be issues around you know, regulatory obligations as well, doing the best for your client and being therefore prepared to say, sorry, no, but I don't think unbundling is for you. So those are the sort of, I think, of the issues that we see, and the sort of things which are on our horizon.
Which leads us on to a question we've actually had here, Paul, is do I need to inform my insurer if I'm offering unbundled services?
Well, what I would say is that we don't, I checked this morning, we don't actually specifically request information about that. But I think if you're making a fair presentation of your firm as a risk, then I think it's a good thing to flag it up, because it does represent a change in the way in which services are being delivered, and it does start to throw up risks which, if not new, are certainly, you know, in a different context. So as an underwriter, as an insured, it would give us comfort, and that's what we'd be seeking, I think, a sort of a sense check. Well, if you are doing this sort of work, how do you go about managing it and organizing it, and, you know, what do you see as the risks as well? So I think, you know, we're not being big brotherish about it. We're not saying if you're doing it, we won't write to you. At the moment, it's a relatively low level of exposure, and this is something which is going to develop over time. But I think certainly it's good to flag it and to be prepared to engage in a conversation. It won't be the Spanish Inquisition, but it will be a conversation about what are the issues and how do you go about managing them.
And Jackie, talking about the firm perspective, obviously Lerla touched on the benefits for the consumer and potential cost reduction. So I guess something here from the firms, what's in it for us? Where are the benefits for us in offering unbundled services?
I mean, I think the benefits for firms are really about attracting more clients and sustaining that client satisfaction over time. Firms do need to obviously have their eye on the current cost of living crisis, and doing some work for a client is better than that client not being able to access services at all. Those firms who took part in the pilot who are offering unbundling, and those firms who answered our survey that were offering unbundling, they talked about that they had seen benefits to their business in being able to attract new clients. And we also know at the SRA that many firms, they're not just in it to earn great amounts of money. They are also there because they are ethical and they want to offer a certain service to clients, and they are passionate about access to justice. And I think that for firms that will be attractive in itself, the feeling that by offering unbundling, they are offering access to justice for some consumers who just would not be able to access a legal services provider without this way of offering the service.
We've got a question from Nigel here, and this may be Jackie or Paul. So he's asking, is one of the potential barriers or part of the reluctance being in the difficulty in defining in a letter of engagement exactly what is and isn't unbundled, and having clear, I suppose, divides between where that falls?
I mean, I think from the research that we did, that is part of the reason. Firms are clearly anxious about how you make it clear what is within the scope of the retainer and what sits outside it. I think there is also a nervousness amongst firms about whether, in the really rare case that something gets to court, that the court will look at the consumer and say, well, they're not a legal person. And therefore, for instance, even if you agreed with the client that they had to submit something to court on time, you should have had your eye on that. And so they're worried that they'll be held responsible even if the retainer is clear where responsibility falls. But we have to say that the negligence cases are really small, and we think the risk is tiny. And actually, I think it's more a perception of risk in firms' minds by seeing some of those headlines than it is a real risk that materialises very often. Obviously, firms always need to think about the client's best interest and always act in the client's best interest. And we will say, if you do that, then normally you will be okay.
And Lola, can I ask you, touching on, I guess, client's best interest, we've got a question here from Kerry, who's wondering, if unbundled services became more and more commonplace, is there a danger of almost disadvantaging and excluding those people perhaps for whom technology, which I guess predominantly is the platform through which we immediately think unbundling may be capable, is more of a barrier, and people don't perhaps have as easy skills in that area? How do we avoid them being almost disenfranchised for this opportunity?
I think that's a really, really great question. And I think it really feeds into this point that we keep talking about, the consumer panel, that digitalization, is not going to serve everyone well. And we have to be alive to that. But I think I will go back to what was said in the beginning, in that unbundling is only it's for a certain and specific type of consumer. It's not supposed to be there to cover everybody. So it may be that as we develop unbundling services to deal with a particular or to solve a particular issue, we think about other ways to address those that might not have or be capable of using unbundling or have access to digital services. But yeah, it's a really great point.
And I guess, as Jackie touched on before, different people have different appetite for control. So we're not saying, are we, that people who are comfortable, who can afford and choose to not unbundle, that in any way is wrong. It's about the choice, I guess.
Yeah.
So Paul, we've had a question here as to, would it help the insurers if there was more of a, I guess, standardized approach to unbundling? Could that be a challenge, that everyone does it, everyone records it in different ways? Maybe touching on Jackie's point about a lack of standard technology to help navigate through this for the providers themselves.
Yeah, that's a really good question. I think at the moment, we're in the foothills here. We're still scoping out the territory, and I think over time it'll become clear where unbundling, as Lola mentioned, works and where it's perhaps not so appropriate. So then we might find over time you do end up with sort of standard bespoke approaches. And that would be extremely helpful. I think at the moment, though, if it's possible, and I suspect in a lot of cases it is, you're being asked, you're asking the client to do a particular discrete thing, or you as an insured are doing a particular discrete thing, then hopefully it's going to be relatively straightforward to spot the demarcation and be able therefore to get your arms really around the risks. I think the challenges are really around when I think as a profession, I mean, solicitors are very keen to help people. And I think in some ways we can be our own worst enemies when we go off piste. So we have these nice clear retainers and then we suddenly do something which takes us outside in terms of scope. So I think discipline around that is good. But ultimately it's a case at the moment, what do you feel comfortable with? Can you identify what the client's going to do, and the client is clear about what you're going to do, and therefore in the circumstances, can you get a sense of what the risks are? And I suspect at the moment they are more apparent than real. But I can understand people hanging back because it's new and different, and we're used as a profession to saying what we're going to do, not necessarily what we're not going to do.
And I guess it'd be new and different. And it's a question for anyone really. Jackie touched on the point about unbundling not being an easy to define term, certainly I guess for the public and the consumers, Lola, and whether there's work to be done in that area as it's advertised. I mean, do you have any thoughts about almost whether does that need to come first really before we can expect people to be aware to the opportunities?
Sorry, you mean do we expect?
Is unbundling as a concept, do you think that's as much the challenge as anything explaining that to the public more easily?
I think unbundling as a concept isn't so difficult. The word itself is difficult, and when you throw it out, people might not know exactly what it means immediately. But once it's explained, I think it's easy enough to grasp what it means. But exactly as Paul said, I think that some of the challenges in this area, I don't believe that we have clear guidance, or even regulatory guidance on things like, ensuring that you agree that a consumer will do this, and just those clear specifics around who's doing what and by when. I think that is more of an issue. Of course, we have to look at the word unbundling, and we have to position it in a way and present it in a way that consumers readily understand. But I think it's a relatively simple concept, even though the word itself can be quite tricky.
And you mentioned there, I guess, support materials, and we've just had a question come in about whether the SRA or others are looking at doing any work in this area in terms of giving law firms some support, some guidance, some information. And I think you touched on some of that, Jackie, in your next steps before.
Yes, that's right. So we are looking at what guidance we can put out for firms. As I said, we have looked through the case law, as limited as it is, that exists around negligence actions in particular. And we'll look at what guidance we're able to put out in collaboration with insurers on that. And we're also looking at what information we can give to consumers and what guidance they might have so that they can go into speaking to the legal services provider about unbundling with a bit more awareness of what it involves. So yeah, that's definitely part of our next steps, just to think about what formal guidance and information we might be able to put out there.
And I guess to both Lola and to Paul, I guess what are the next big things or the next steps which you feel from each of your perspectives would help move forward, I guess, the case for unbundling and the take up for unbundling?
I don't think that we will address the take up until we really address providers' concerns. So I think that is absolutely key to seeing some progress in this area. So I would really welcome the next steps that Jackie has set out. I think those are exactly the right steps that we should be taking. I think coupled with that, it would be really useful to see if the legal ombudsman have received complaints and how they've dealt with it, and if that can be weaved into some of the guidance. I think that would be really helpful.
Yeah, I think we are in this, we're at an initial phase here. So as we get more information, as we get a greater sense of where the challenges are, what are the issues, then we can start addressing those and hopefully provide some comfort to people who want to set off in this area. As I said earlier, I can understand absolutely the drivers which are making unbundled services an option, a more attractive option for a lot of people. So there's nothing to stop unbundled services per se. So we're going to have to start getting a sense of where the challenges are, and today and for the foreseeable future, we're going to be involved in conversations where we start to scope that out.
I've got a few more questions, but if anyone listening has got questions they want to get in, I'd say we're sort of in our last 10 minutes, so by all means, get them in. So Lucy has asked, in terms of liability, Paul, when you've essentially unbundled and identified the service that the consumer is going to deliver, is there a potential barrier if they're struggling to almost jump in and help them, because almost you've already hived that off as something they're responsible for from a risk perspective?
Yeah, I get the impression from my initial reading of the cases that you want to avoid a situation where, having set up a fairly clear retainer, you then engage in conduct which suggests that the retainer has been expanded. So I think it's something which, and this is not, this is not unique to the situation where you have an unbundled service. I think it's something which we see from our perspective as insurers of legal professionals. We insure generally, that the whole idea of scope and staying within scope sometimes gets lost. You're taken on to do a job of X, and then you get a request to do something else, and then suddenly you're doing X plus Y, but you're only charging for X, and you only got enough time for X, and that's when the problems start. So I think there is a need for discipline to avoid stepping over the line. And if you do find yourself thinking, right, we're getting close to the edge here, then you're going to have to go away and renegotiate what that original retainer is. And maybe in that situation it becomes a question of, well, all right, unbundling looked like a way forward at the outset, but maybe we need to reconsider whether that's the way now, and then give it to the client as that option. Look, we appreciate we had the conversation, it's not worked out, how do you want to play this? But I think it's about being alive to that as an issue, and B, spotting it before it becomes something which takes you over the edge, you're out of scope, and then it's, then you are into liability issues.
And I suppose, Lola, that comes back to something that was touched on before about understanding a consumer or client's capabilities to unbundle and being realistic about that from the outset.
Absolutely.
Speaking of, I guess, consumers and different types of consumers, a question from Nigel, and I don't know, Jackie, if we've touched on this at all, but whether we got any sense of whether unbundling is more prevalent or more appropriate in a business to business versus a consumer member of the public environment at all.
Well, our research focused on individual consumers, and that is largely where we see unbundling happening, is amongst individual consumers. So we don't have evidence that business to business is where it is more prevalent. But you can see by sort of logical extension that when we talk about confidence and when we talk about capability, that businesses will employ some staff who feel they are able to do some of the work themselves, and they just need a legal professional for small parts of it. So that could be something that we go on to look at as a next step.
Fantastic. So I think we've reached the end of the questions we've had in thus far. I don't know if any of our panel would like to leave us with any thoughts at all. If not, I think we will say we are going to do a lot of work in this area. I think it's fair to say over the coming months and beyond. So hopefully this won't be the last time you hear about unbundling. There's going to be resources made available, and in fact, if you look below this video, you will find a link to some of those. I'd also like to mention we've got a lot of other work coming up that we hope to come and speak to you about shortly. You can see it on the SRA's website on our events page, and in fact our next webinar taking place in early October is going to be on a potential new approach to the financial penalties regime. And then beyond that, we've got our annual compliance conference taking place in November, where this topic, everything from technology, solicitor qualifying examination, compliance queries, sanctions, money laundering, there'll be something in that for everyone. So by all means, go and have a look at our website. It's a free to attend event, and there's lots and lots of sessions. So for now then, I'd like to say thank you to Jackie, thank you to Paul, and thank you to Lola, and most of all, thank you to those who watched today and submitted questions. Thank you.